on trademarks and IP rights. This session is one of a series of interactive webinars held by Field Fisher's Brexit Task Force, and we will be hosting a 30 to 35-minute session every Thursday at 10 o'clock for 9 weeks, covering significant legal developments, hot topics, and offering practical advice for businesses and organisations in this ever-changing environment. As you of October. So we'll just briefly introduce ourselves. So my name is Amy Reynolds. I'm a partner in the IP and TPE team in our London office. And I'll be one of today's presenters and moderators. So I specialise in trademark and brand protection law, and I have over 14 years of multinational experience in this field. I also advise local and international clients in relation to all aspects of brand protection, which includes trademark clearance, prosecution, validity actions.
My name's Jude Anthony. I'm an associate in the IP and TPE team in our London office, and I'm also one of today's presenters. My experience covers a broad range of trademark and brand protection law, including portfolio management, trademark clearance, trademark registration, and trademark disputes.
Hi, my name is Matthias Berger. I'm a partner in the IP and TPE team here in Hamburg. I will also be one of the presenters today. My experience covers all relevant aspects of trademark, design, patent, unfair competition, and copyright law, and I'm also active in internet law-related questions.
Okay, if you have any questions as we go along, please do use the question box in your control panel. It's on the right-hand side of the screen, and at the end of the session, we'll try and get through as many questions as possible. If we don't have time to answer your questions today, we will follow up with you individually, official website, and also our YouTube channel. So let's get started. So in today's session, we're going to be covering the current position in relation to trademarks, what comes next for trademarks, including associated issues such as exhaustion and domain names, the steps that you should be taking now, plus some tips on where to find some additional information and who can help you if you've got any questions. And as I said, we'll also have some more time for questions at the end. So just a quick recap. With effect from the 31st of January this year, the UK did leave the EU under the terms of the ratified UK-EU withdrawal agreement. We're currently in what's been called the transition period, and the transition period will end on the 31st of December this year, at which point the withdrawal agreement will be fully in force. So what does that mean for trademarks and IP rights? Well, it has been largely business as usual from an IP perspective during the transition period, despite of the obvious ongoing issues with the COVID pandemic. The UK does continue to be part of the EU insofar as protection of EU IP rights is concerned during this period, and at the moment the UK continues to apply and implement relevant EU law. The UK government has put in place a range of regulations providing for the protection of EU and UK IP rights when the transition period comes to an end. And the UK IPO, in turn, has produced a large number of guidance notes which flesh out the arrangements set out in the regulations. The European Commission has also produced a range of readiness notices, and the EU IPO has made
So once the transition period ends on the 31st of December 2020, a new regime comes into place where the UK is no longer part of the European Union trademark system, but measures are in place to protect the rights of EUTM owners in the UK. On 1 January 2021, once the transition period is over, all registered European Union trademarks will be cloned as UK national registrations. This will happen automatically at no cost to the trademark owners, and the new UK national rights will be given the prefix UK 009, which will make them easily distinguishable on the register. For EUTM applications that are still pending on 1 January 2021, The process is slightly more complicated as these will not be cloned automatically. However, owners will have a 9-month window until 30 September 2021 within which to apply for a UK national right backdated to the same application date. There are several disadvantages in that owners need to actively apply and pay for the application, which will then be examined by the UK IPO where it may meet official objections or third-party oppositions. A third party can apply to cancel a trademark registration where that mark has not been used for an uninterrupted 5-year period. Likewise, in an infringement action or trademark opposition action, a trademark owner can be required to provide proof that the mark has been used in the preceding 5 years within the relevant jurisdiction. In both cases, for UK rights cloned from EUTMs, use in the EU prior to 1 January 2021 will be sufficient. This means that owners of these registrations will have 5 years to start using their trademarks in the UK before they become vulnerable to either non-use cancellation or run into proof of use issues in infringement or opposition proceedings. The position for EU designations of international trademarks is the same as for EUTMs. This had been unclear for some time after the position became known for EUTMs, but was resolved in June this year. So owners of EUTM designations of IRs will also be granted comparable UK designations of their IRs, and this process will happen automatically at no cost to the trademark owners. The new UK designations will be given the prefix UK008. As with EUTMs, the IRs designating the EU that are still pending at the end of the transition period will not be automatically converted, but owners given a 9-month period to file UK designations benefiting from the same designation date.
Thanks, Jude. So one of the interesting questions which has come up is whether use of a EUTM in the UK could count towards use in the EU for the purpose of maintaining rights conferred by an EUTM. We waited quite a long time to get some clarification on that, but in a joint notice dated the 18th of June this year from the Commission and the EU IPO, it was confirmed that this was not the case. However, such use before the end of this year might count if it relates to the relevant period for which use has to be shown. So the significance of that use for the overall assessment of genuine use in the EU will naturally progressively decrease over time. When relying on use and reputation of an EUTM in proceedings going forward, the EUTM must be reputed in the EU at the time that the decision is taken. So that means you won't be able to sustain or contribute towards the protection of an EUTM in this way. Also, from the 1st of January 2021, UK rights will cease to be earlier rights for the purposes of EU IPO proceedings between parties, and the UK territory and the UK public will no longer be relevant when assessing conflicting rights. However, evidence of proof of use in the UK and from the end of the transition period, any pending or new opposition or invalidity actions before the EU IPO that are based solely on UK rights will be dismissed.
All right, next slide, please. Let's turn to another aspect, the exhaustion of rights. Under EU law, once a good protected by an IP right has been lawfully put on the market within the EU by the right holder or with his consent, the rights conferred by that IP right in relation to the commercial exploitation of the good become exhausted. In that case, the right holder can no longer invoke that IP right to grant the further resale, rental, lending, or other forms of commercial exploitation of the good by third parties. Now, what changes? After the end of the transition period, EU law providing for the exhaustion of IP rights no longer applies to the UK. So that if a good protected by that right has been lawfully put on the market within the UK, the IP right will not be exhausted in the EU. This is still one thing that is negotiated during the ongoing trade negotiations between the UK and the EU right now. We will have to see if there will be some kind of agreement, but for the time being, you should take that into account, that there will be a tremendous change, which will impact IP right owners as well as parallel exporters. On the other hand, IP rights in goods that are put on the European Economic Area market will continue to be exhausted in the UK, so there will be no change there. Just to refresh your mind, the European Economic Area, the EEA, consists of all EU member states, Norway, Liechtenstein, and Iceland. What should you do now? When you're an IP rights holder, you should consider if you still want to allow parallel exports of IP protected goods from the UK into the EEA after January 1st. But even more importantly, for parallel exporters, you should review your business model and all your business arrangements and your supply chain and consider whether you will need permission by the IP right holder to continue your business like it was before. And you should start negotiations with the IP right holders right away, since there's not much time left until the end of the year. Okay, next slide. Let's have a look at a totally different aspect, EU domain names. And I'm sure that many of you have registered once for your companies. Many UK businesses have, but not also UK businesses, but also continental European companies that have such domain registered in the name of one of their UK affiliated companies, particularly when those owned a trademark which is identical with the domain name. This provided certain advantages when registering the domain name during the early bird period, so when the whole EU domain name system came into place. Now, the rules will change as follows. From January 2021, to continue to be able to hold and register EU domain names, UK persons and entities must either be an EU citizen, a natural person who is not an EU citizen and who is a resident of an EU member state, or an undertaking or organization that is established in the EU. Any UK person or entity that does not fulfill these criteria will no longer be eligible to hold an EU domain name. On October 1st, 2020, UK-based owners should have received a notification by EURID, the domain name register, that they will lose their eligibility as of January 1st, 2021, unless they meet the criteria and can demonstrate this. There will be another notification coming from EURID on December 21st, 2020, which will be sent to those UK-based owners who have not demonstrated their requisite compliance with the eligibility criteria. And as already mentioned, as of January 1st, 2021, any UK registrant who did not demonstrate the necessary eligibility will have their EU domain name withdrawn. It will be removed from the zone file and will no longer function as a domain name, so will be unable to support active services such as websites and emails. So this is very important. Upon you should check, we have some tips later on. EURID has also issued a notice regarding the new rules, and you find the link in this slide.
Thanks, Matt. So we have put together some tips on what you can do to ensure you're not caught out or disadvantaged by the upcoming end of the transition period on 31 December this year. Next slide, please. So we recommend that after in January next year, you review your trademark portfolio and incorporate details of the new UK national rights. You'll also need to assign representatives for the new UK national rights to ensure that no correspondence from the UK on these rights is missed. The UKRPO is consulting as to whether it will continue to allow representation by EU-based agents, but in all probability it will not, and a UK-based agent will be required. The good news for Field Fisher clients is that we are a Europe-wide firm with offices in the UK and throughout the continent, so we continue to be able to handle both UK and EU trademark work as well as national rights in major EU member states. Owners of EUTMs who have primarily used their trademarks in the UK up until now should review their commercial strategy to minimise the risk of their EUTMs being vulnerable to attack in the future on the basis of non-use. You'll remember that there's a window for 5 years within which use in the UK will still count as use in the EU, but obviously they should look to take steps for when that window ends. The options include expanding their market into the EU as well as refining their systems for archiving evidence of use if they are using in the EU, so that there are separate records for use in the UK and the EU. You should also review any pending EUTM applications that you have and consider whether UK national equivalent rights are required. Take note of the 9-month window to convert pending EUTMs to UK national rights, as this deadline will come up quickly. If you're filing EUTM applications now, you should consider filing UK national applications at the same time. New EUTM applications will not register prior to the end of the transition period, so it may be better to file the UK applications with the UKRPO directly rather than relying on the conversion process.
Next slide, please. So I have already mentioned what parallel exporters should do. Again, please review your business models, all your current arrangements to make sure that you will be able to continue with your business like it is. This might involve negotiations with IP right owners in all those cases where you will need their consent in the future. It might be that there will be a solution during the trade negotiations between the EU and the UK, but right now I think you should start to find solutions for the case that we will have a so-called hard Brexit. EU domain owners who can still satisfy the eligibility criteria in cases where you have a registered office or a central administration or a principal place of business within the EU or EEA, or you are established within the EU or EEA, or you're a natural person resident in the EU or EEA, you can check and consider if EU domain names should be transferred, for instance, to such entities, so you can continue to operate your EU domain name. If it is not possible to maintain your EU domain name, you should think about acquiring new domain names, such as .com or .net or .co.uk, and you should do that now to be prepared on January 1st. And even more importantly, you should consider developing a migration plan for services and functions that your EU domain name currently supports. The website or associated email addresses, as I said, will not work anymore. So you should put everything in place within the next 3 months.
tips. What can you do, and who can you ask if you've got any questions? Okay. So this next slide contains some links to the UK legislation and guidance on IP if you need more detail on any of the points that we've covered today. There are also publicly available resources regarding Brexit, which we've linked on this slide. If you'd like to use any of the Field Fisher resources, we've got a Brexit blog. We've created some practical checklists, and we've also got a task force and a hotline in addition to this webinar series. And coming soon, we're publishing a Brexit and intellectual property briefing paper, which is about to be published, so please do keep your eye out for that. As I mentioned before, we've put together a Field Fisher Brexit task force. The practice areas and the main contact details for the relevant partners and solicitors are set out on this slide. And we've also provided our own contact details from the seminar today at the end of the presentation if you want to get in touch with us. Okay, so now we've got a few minutes to take any questions. So please do fire away. As I mentioned before, you can send us questions in the taskbar to the right of your screen.
Hi everyone, we've had a few questions in, so I think we've got a time for some of them. One of the first questions is, what happens to licenses of EU trademarks from next year?
Matt, would you like to take this one?
Sure, I could. Sorry. Licenses. So I think any license or also assignment or security interest relating to an EUTM will apply to the comparable UK right, which you get. So we recommend that EU owners notify any licensees that from January 1st, the license will also apply to this UK comparable right. And you should also check that the creation of the new right does not breach any clause of the license agreement, which it could, theoretically, or any other agreement to which you are party. So checking all your current existing agreements, I think, is key. There will also be a period for recording a license or other transaction on the UK register. That one will be extended from currently 6 months to 12 months, and that counts from January 1st.
Thanks, Matt. Another question just in is, what happens to pending proceedings in the UK about EU trademarks from next year? Don't know who would like to take that one.
This one. Yeah, I can take this one. So from January next year, the UK courts won't be able to act as EUTM courts. If the proceedings are for trademark infringement, then the court can grant an injunction, but it will only be able to do so in relation to the UK equivalent rights, not the whole EUTM. And if the proceeding is that's in the UK relates to cancellation, then the court will be able to revoke again the UK equivalent right, but it won't be able to touch the remaining EUTM right.
I will get more questions coming in. I think we've got time for maybe one or two more. Here's one. Can a UK company be the representative on record with the EU IPO for EU trademarks after the end of this year? Or does it need to be an EU resident company? Who would like to take that one?
I can take this one, yeah. So the answer is that a UK company cannot be on record with the EU IPO or act in EU courts after the 1st of January. But where companies or firms like Fieldfisher have offices sort of throughout the continent, then we can continue to act with no disruption. But if you're a solely UK-based firm, then you will lose that right.
Thanks very much, Jude. The questions keep coming, I'm afraid. Should we take one more? When we get new UK registrations, the cloned ones to replicate our EU trademarks, will we need to record our licenses against the new UK registrations, or will that be copied across as the license is already recorded against the EU registration? I know the IPO keeps on issuing new notices. Do we know the position on that? Anyone like to take that one?
Since I talked about licenses, I think the situation is not quite clear yet. I'm not sure if there's clear guidance by the UK IPO right now, but as I said before, I think you will need to re-register, so to speak, your license. There was talk about this extension of the time you have from 6 to 12 months. Amy, do you know more?
Yeah, that's my understanding too, Matt. So we're recommending that people do record against the UK equivalent, because it's not 100% clear at this stage, but it's likely that you will need to do that.
Yeah.
I think that's all we've really got time for.
Have we got time for any more questions, or should we? Okay.
I think.
Okay. Well, as I said before, if we haven't had time to answer your question today, I'm sorry about that, but we will follow up individually with people who've asked questions, so we will get back to you separately about that. I just wanted to say thank you very much, everyone, for joining today's session on the impact of Brexit and on trademarks and your IP rights. We do hope that you found it useful. And as I did mention earlier on, all of our sessions are recorded, so if you want to go back and re-listen to any of it, you can find it on our website and also the Fieldfisher YouTube channel. As I mentioned before, we'll follow up individually with anyone whose questions weren't answered today. And if you would like to get in touch with any of us to discuss any of the topics we covered today further, then please do send us an email or give us a call. We've put our contact details on this slide. And so thanks very much for joining us. I hope you keep safe and well, and we also hope that you can join us for next week's topic, which is going to be on data protection. Thanks very much, everyone. Bye.
Thanks, everyone. Bye.